Welcome to the Same Day Podcast, where we discuss driving incremental business growth and other topics related to real estate, property management, and entrepreneurship. Now to the show at hand.
Matt Zalk here. I'm the host of the Same Day Podcast, where I connect with top business leaders and real estate experts. Past guests include Miles Thompson, a real estate investor and investing coach to others, talking about portfolio optimization strategies, and Keely McEwen, who serves as Vice President of Governmental Affairs at Tinker Federal Credit Union, discussing advocacy and lobbying for small and medium-sized businesses. Today's episode is brought to you by Keyrenter Property Management. At Keyrenter Property Management, we are a full-service property management company helping our clients buy, renovate, and operate real estate assets. We help our clients build wealth while taking the headache out of property management. And taking the headache away is a key point. Listen, some property management companies are your first line of defense against litigation, while others seem to go out of their way to increase property owners' exposure and liability. But at Keyrenter, as you'll see from today's show, we try to stay abreast of current affairs in our industry so that we continue to take the headache out of property management. And that's why no matter what rental you have, single-family homes, townhomes, condos, apartments, we have the management solutions you need. Go to KeyrenterPMC.com to see if we manage in your area. Liz Roussel, today's guest, is a litigator at Adams Reese in New Orleans, where she has worked her entire 23-year career, generally representing companies in management to defend their business decisions. In addition to engaging in a full-time practice of law, she manages the firm's litigation practice across all of its 20 office locations. Liz Roussel, welcome to the show. How are you?
I'm good. Thank you for having me.
I'm so excited to talk to you. And I said this before, but I'll say it again. Thank you. On behalf of all the property managers and property owners in the world, thank you for taking on this case. Thank you for winning, which I wanted to get into a little bit later, about the merits of victory and loss in a case like this and how it kind of goes to the appeals process. But thank you for winning. Thank you for doing this. And thank you to your client for really taking this charge on, because it's long overdue and is hugely impactful. I mean, this is one of those things that's just such a niche issue that affects so few people from our perspective, from the property manager perspective, but is so vitally important. So thank you. First and foremost.
Yeah, you're welcome. It's my pleasure to work on the case. And I agree with you. It's really my client who deserves the credit for seeing this through to its conclusion.
100%. Yeah, I love that. Today we're talking about Henderson versus 5 Properties LLC. For our listeners who have never heard of this case, don't understand what was at stake, and just generally are in the dark about this case, can you give us a quick summary of the case and what was really at stake?
Yes, happy to do that. So my client in the case, I actually had 2 clients, but essentially a housing provider, had a property in Kenner, Louisiana, where the plaintiff lived, called the Almond Tree Apartments. And the plaintiff rented an apartment there initially with a dog, didn't identify the dog as an emotional support animal, and paid a required one-time $350 fee. That lease was scheduled to expire in November of 2023. And as the lease was coming up to expire, the plaintiff sought to move to a different property that was also managed by my client, called Sun Lake. In the process of making the application to apply to Sun Lake, the plaintiff told my client that her dog had become an emotional support animal. The dog that had lived with her for, at the prior apartment had become an emotional support animal. She was getting documentation, and she was going to provide that documentation so that she would not have to pay what was at that time a one-time $400 animal fee. Initially, she provided a letter from the internet, and we learned in discovery, and I'm sure this won't surprise you, Matt, that in order to get the letter from the internet, all she was required to do, it took about 10 or 15 minutes, was go onto a website, answer some questions in a drop-down menu, pay an amount, which was less than the one-time animal fee. And then she received a letter from a doctor who she never spoke with and never communicated with. So when she presented that letter, obviously my client said that wouldn't be acceptable. She said she was going to go get some better documentation. And so she actually, in this case, delayed her application to move into Sun Lake while she was going to get this better documentation. Interestingly, during that same time period, she applied to rent at another place. This is just sort of an aside.
Yeah.
And they wouldn't accept the internet letter either. And eventually they had sort of a long wait list, but she had told them that she would move in there without the dog, which really called into question whether she needed the emotional support animal at all. In any event, eventually she returned to Sun Lake to complete her application, provided information from, a typical letter that I'm sure you all see all the time. It was general in nature and simply said, my client has an undefined, unspecified mental or emotional disorder that requires them to have an emotional support animal. The letter didn't say anything about needing a fee waiver, just that the tenant was going to need an emotional support animal. What was so unique about this case is that this dog was allowed on the property. There was no problem with having the dog on the premises because the property allowed animals. The only issue was whether the tenant needed a fee waiver as a reasonable accommodation. And that, as you know, is an issue of importance. And this case presented the opportunity for it to be decided squarely. And in any event, ultimately, my client responded to the request for the fee waiver and said that they didn't see a nexus between the disability and the need for the dog or the need for the fee waiver, but not having, there was no problem having the dog, but they would not waive the fee. They proposed more than once to allow the tenant to pay the fee over time if that would help. And rather than do that, she canceled her application, went to the Louisiana Fair Housing Action Center, and brought a lawsuit under the Fair Housing Act and under Louisiana's corollary state law, alleging that she had been discriminated against based on her disability because the company had not waived the fee for her. And so you ask the question, what was at stake in this litigation? Basically, what was at stake is the question of whether the Fair Housing Act requires housing providers to automatically waive fees for people with assistance animals. That was the question. That was what was at stake. And that was the issue that my client thought was significant enough to see through to the conclusion of the litigation to try to get an answer to.
But for your client, what was immediately at stake, of course, they opted to take a longer term perspective, which I love, but the immediate stakes for this case was HUD's offensive litigation against them and the fine they could face, which is enormous, for denying that the applicant a reasonable accommodation and that fee waiver. How did it come to be that we were all so afraid of the repercussions from HUD in the event that they would sue somebody for fair housing discrimination based on a disability?
Yeah. So, it's really interesting. Obviously, as you point out, there are consequences for violating the Fair Housing Act. Yeah. What's really interesting is that HUD issued this notice in 2020 that said, and I got this because I want to make sure I didn't get it wrong, and you all know it, a housing provider may exclude or charge a fee or deposit for pets in its discretion and subject to local law, but not for service animals or other assistance animals. So the notice that was issued in 2020 by HUD was explicit and specifically said, you can't, thou shalt not charge a fee for an assistance animal. And so I think the notice does say that it's best practices, it's guidance, it's got some limiting language in it. It suggests that it's not necessarily indicative of how HUD is going to enforce the Fair Housing Act, but those are the words. And then the actions that followed that, as I'm sure you and others know, is a lot of enforcement consistent with that. And so, it did become sort of like the gospel that you can't charge for a fee for emotional support animals. And I think it became that way, not just because that's the way in which it in fact was enforced or has been enforced, but also because internet, the people who are selling these letters on the internet say, if you buy this letter, you may not have to pay the fee, which is obviously an incentive to buy the letter. And then, frankly, Matt, I think that because of all the enforcement, a lot of companies, just rather than fight this because of the expense and the risk and the rest, just agreed to enter into consent decrees to change their policies and to say, fine, if that's what you want me to do, we'll just change our policy to say that we're not going to do this. And so it became a practice. And I think what now has happened is people don't know what the origin of this automatic fee waiver requirement that everybody thought was a requirement. Nobody knows what the origin of that is. But what this case demonstrated is it's not the law. It's not the Fair Housing Act. It was this non-binding guidance that you could argue is wrong.
And in our companies as property managers, it was this Pavlovian response where, again, nobody knew the origin or the rationale. It was just taken as gospel. And we would quake in our boots at the thought of violating fair housing and violating somebody's HIPAA rights and asking any questions at all. I mean, it's to such an extent that we've outsourced a huge portion of pet screening to companies that take on that liability for us to ask specific questions because it's their business to know which questions you can ask of these situations. I mean, it's just absolutely nuts. Anyways, there was a case that preceded Henderson versus 5 Properties LLC. And before we get there, one second, I want to just ask on the process side for your client. I mean, did they ever realize that this was something that would come about when they questioned the legitimacy of the fee waiver? Was this something that they were looking? I mean, I know in many cases that ultimately make it to the Supreme Court, it's essentially like a set up case. And I can think of some that are probably not appropriate to talk about on this podcast, but that I've learned about in the past. And I don't know any specific, ones that don't have sexual content in them or are more explicit. But like they set up a case where somebody gets busted for doing something that they think is an overreach and unconstitutional, such that it can be appealed, and that reaches a Supreme Court verdict. Did 5 Properties have any idea that this is going to become a landmark case, or were they just like, I'm tired of this and I'm putting my foot down? Like, how did it start with them?
Yeah, so I wish I could say that I knew. I don't think this was intended to be a setup. Frankly, I think they confront this issue so often that it could have been this case or it could have been another case. But we did recognize early on in this litigation, as we making decisions about how to proceed with it, that what was unique about it was how squarely this issue was going to be presented to the court. Because there are a lot of cases, well, not a lot, but there are, when we looked into this, we couldn't find any cases that had squarely addressed the issue. Mm-hmm. There's some that have tiptoed around it. There are some that come close to the issue, and then the judges punt and they decide it for some other reason. And, to her credit, I really respect and appreciate Judge Vance for taking on this issue. Absolutely. Because like every other case, there are ways that this case could have been decided differently without having to reach this issue. But this is the issue we wanted decided once and for all, because we believe the HUD guidance was wrong and not consistent with the law. Yeah. And so we actually, in the course of the case, actually teed up this particular issue of necessity early and independently in hopes that it would be decided. But ultimately, the court could have decided it, I guess, on other grounds. But I don't think there was any specific intention to get this, to set up this plaintiff. But there was a recognition after she initiated the litigation that this case presented an opportunity to get an important issue decided.
Do you think it's a fair characterization? I'm not an attorney. I don't play one on TV. Is it a fair characterization that some of the cases that do go before the Supreme Court are like crafted, so to speak? I mean, that's a real crime. It's a real response, but that ultimately it's like they're kind of manufactured to get to a place where a decision on a law or I guess case law or whatever is like the deciding factor for future, for the future.
Yeah, that certainly does happen. Okay. In order to get cases to the Supreme Court, a lot of times the pathway to get there is to have splits in the circuits and have the circuit courts, the appellate courts, decide issues differently. So you have different application and interpretation of the law. And so the Supreme Court needs to come in and say, this is the correct interpretation. So sometimes, yes, that does get teed up in that way in order to achieve the goal of getting it where it can be resolved once and for all. But I can't say that that happened in this case.
I want to just make sure that I wasn't totally mischaracterizing some of the stuff that ultimately gets out there. It was my understanding, but I didn't want to mischaracterize. So where I was before, there was a preceding case in Loper, Bright versus Raimondo that set the stage for this ruling. Can you help us understand that case a bit?
Yeah. So that was a really significant case that was recent case from the United States Supreme Court. And it has to do with how courts are supposed to address or defer to or not defer to agency guidance like the HUD notice. And so for many, many years, there was a doctrine called Chevron deference, which was, as the Supreme Court recognized in the Loper Bright case, a judicial invention. But the courts had come up with a construct where they initially would give deference to an agency's interpretation of the laws that that agency enforces. And so courts, when considering something like this case, in a pre-Loper Bright situation, the judge might have said, and some courts did say, like the Intermark case that was cited by the plaintiff in this case, we're going to defer to the agency's interpretation because it's the one that enforces the rules. And that was the starting point, was to give the agency guidance deference. In Loper Bright, the Supreme Court came and said, that's not correct. That is not what you're supposed to do. It is the role of the courts to interpret the Constitution and to interpret statutes. And it is not the role of the agencies. And so you should not give deference to agency guidance. And instead, what you should do is only respect it if it has the power to persuade. And you should evaluate whether you're going to give it any weight based on factors like, is the agency guidance based on some sort of thorough analysis? Is the agency guidance consistent, from year to year and administration to administration or whatever it might be? And is it based on sort of law, and is it supported? And so how that became really important in this case, and Judge Vance relied on it and cited it, is that while we argued, you should just look at the Fair Housing Act and what the requirements are as a matter of law to determine when an accommodation is needed and when and whether it is reasonable. What the plaintiff argued is, no, you shouldn't do that. You should just follow the agency guidance. HUD issued a notice. HUD's notice says you can't do this. And so at that point, what Judge Vance said is, okay, well, let's go through the analysis. Loper Bright says, I don't give deference to that. And so the question is, does it deserve any weight? Is it persuasive? And she explicitly found, looking at the notice, that HUD's notice is unpersuasive. And she did that by saying, if you actually look at the notice itself, it cites a joint statement from the Department of Justice and HUD from years earlier that had no legal support, no analysis, nothing to evaluate. It cited two cases that had nothing to do with assistance animals. And then it cited one case called Goldmark that was distinguishable because it had to do with a policy that treated disabled people differently than non-disabled people, whereas our case involved a generally applicable animal fee. And so she went through a very reasoned analysis to say, these statements that everybody, as you said, have taken to be gospel and have treated as though they are the law are unsupported and they're unpersuasive. And so they're not going to dictate the outcome in our case. Instead, we're going to apply the law the way the law is written.
Does this mean that there will be very specific landmark cases against many other government agencies that have been in the era of the Chevron deference doctrine? I can't remember what you call it. Like, that they've been issuing essentially law, even though it's guidance, that there's going to be a ton of other agencies that are kind of on notice?
I tried to prevent that, but something rang through, so I apologize. But I do know what your question was. So to answer your question, let me say this. I think a lot of agency guidance does probably deserve deference.
Sure.
It is based on thorough reasoning. It's consistent, from over years, it's been their guidance. And, generally speaking, I think a lot of agency guidance people would do well to follow.
Yeah.
I would also say that HUD's notice, the part of the notice that Judge Vance rejected is very specific and relates to, whether one statement that they made, which is an important statement, right? You automatically have to waive fees all the time for anybody who has a subsistence animal, is unpersuasive and isn't binding and so forth. But that doesn't mean that there's not other things in the notice or in the guidance that HUD's been
persuasive
that are and that people should follow. And so it is certainly true that litigants are going to rely on Loper Bright to say, hey, judge, the agency got this wrong. You should find this guidance unpersuasive, and there will be litigation about that. But I think there's a lot of agency guidance out there that's probably,
solid and founded.
Yeah, absolutely.
Yeah. So Judge Vance made this ruling, but that was in the Eastern District Court of Louisiana. Or that's the Eastern District based in Louisiana. What compels a judge in a different area of the country to be bound by that decision made by the Eastern Louisiana District Court? Is it something that we can now rely on?
Yeah, no, unfortunately not. So this opinions that are issued by district courts in any federal judicial district are binding on those parties alone. You could, in this case, Louisiana Fair Housing could take a similar case tomorrow, and if it was assigned to a different district judge in the same district, they wouldn't be required to rule consistently with Judge Vance's ruling. However, courts do tend to, look to other cases that address the same issue and determine whether they find them persuasive. And if so, they rely on them. So it has the power to be persuasive, but it is not going to be binding on any other court.
Got it. So from my understanding, the way for a court opinion to be binding on other areas is either for it to be a Supreme Court ruling, or maybe there's another way, like a broader court, an appellate court.
Yeah.
Right?
Yeah, exactly. Yeah.
So notwithstanding the notion that your client was happy to win this case, from the perspective of property managers, is there not an argument to say that that we would have liked them to lose this case and win it on appeal at a higher court, which would then force it to be incumbent on judges everywhere to take into account? So
I'll always take the win.
Yeah, for sure.
But yes, I take your point. It's a good point. The plaintiffs in this case did not choose to appeal this decision. It is final, and the period of time for them to take an appeal has passed.
Yeah.
It would have been great from my client's perspective for them to take the appeal. In this case, it would have been to the U.S. Fifth Circuit Court of Appeal. And if it was affirmed, it would have been binding on all of the federal courts within Louisiana, Mississippi, and Texas. And that would have been tremendous. And I do think it would have stood up at the Fifth Circuit, because I think it's correct and it's well reasoned. And I think that's the reason it probably wasn't appealed. So yes, it would have had a greater, more binding effect if it had been appealed and affirmed. But I think that this opinion is going to be followed, because I think it's right.
Yeah. So as we mentioned earlier, the former HUD notice or guidance was something that forced us into this feeling of fear and being trapped. And the decision was either accept every ESA request or risk violating the fair housing law. How should we as landlords now consider evaluating ESA accommodation requests?
Yeah, so that's a legitimate fear. I mean, just because the court in this case did what it did doesn't mean that the Fair Housing Action Centers or the Department of Justice, when pursuing claims on behalf of HUD, is going to do anything differently. Yeah. And so, I wouldn't propose, and I don't want to give legal advice to anybody. I don't know different states' laws differing and that sort of thing. But what I can say is that Judge Vance's ruling gave a good roadmap about, what to do in determining both whether a request to waive a generally applicable animal fee is necessary and whether it is reasonable. And, in my view, based on the roadmap she gave, it's going to be difficult for tenants to meet what is their burden of proof. So just to be specific, what she said was, in evaluating whether a request for a waiver of a generally applicable fee is necessary, you can inquire about whether it is indispensable and essential to ameliorate some effect of the tenant's disability. And if they cannot prove that it is essential, then they aren't going to be able to prove that it is necessary. And then when evaluating whether the fee is reasonable, what the court says, well, let me go back actually on the issue. This was on the issue of reasonableness. On the issue of reasonableness, it says, you should look at things like, how does the fee compare to the overall cost of the housing? In other words, is the fee itself reasonable? You should look at, does the fee have a disparate impact on people who are disabled? In other words, what is the proportion of people who are non-disabled who are paying the fee as opposed to people who are disabled? And the implication there is that if everybody's paying the fee and it's not having a disparate impact, then it's more likely to be reasonable. She said you should look at the overall importance of the fee to the landlord's revenue, and you should look at the overall importance of the waiver to the person who's requesting it. And so, I think if you apply, and they've got to meet both of these standards, right? Like a tenant has to prove both, I need this, it is essential for me to have this. Without the fee waiver, I am going to get no ameliorative effect to my disability. And they're going to have to prove that it's reasonable to waive it under the circumstances. And that's what, this case was just about a fee waiver. And that's really important to remember. But this standard is the same standard that you need to evaluate when considering whether somebody should be entitled to have an emotional support animal to begin with. Now, that would have been a more difficult case to defend for sure. But what's important is that also is, it's the same standard that you need to go through. Do you need this? If you don't have it, are you going to be able to ameliorate the effects of your disability? And is it reasonable?
Yeah. The challenge that I have with some of that language, and I imagine this would be echoed across many other property management companies, is we don't employ attorneys. We're employing people that do not have advanced degrees in law. And so having them interpret whether the waiver will indeed ameliorate the disability. I guess it doesn't. It somehow reduces the effect of the disability, and whether the fee waiver is indeed critical to the person's, is critical relative to the person's overall income, can be subjective and shouldn't be put into the hands of people that are not experts. So it's like, given the still significant risk that's posed by getting this wrong, it seems scary to me to put this in the hands of our individual property managers across, 5 states and 7 markets.
Yeah, I understand that. I guess I would say this in response to that. I do think this opinion gives you the ability to say, at least, the one judge who has considered this issue specifically has said, this is not automatic. This is a case-by-case issue. And it is the tenant's burden to prove. And so when people are requesting an accommodation, it's not inappropriate to say, prove that you need what you're asking for. The other thing that's important about this opinion is, and this is consistent, this is in reasonable accommodation law, whether you're talking about the ADA or the Fair Housing Act or whatever it is is that people aren't necessarily entitled to the accommodation they prefer.
Yeah.
They just need an accommodation that is effective. And so the court pointed out in this case that allowing somebody to pay a fee over time can be effective in accommodating their concern if they truly can prove a nexus between their disability and their need for a fee waiver.
Does that mean that if a person in a wheelchair needs a ramp, that the ramp that the courts couldn't force the landlord to put in a concrete ramp when a wood ramp would suffice? I mean, is that like an analogous situation?
It sounds like it could be. I mean, it's, again, as long as it's going to serve the purpose to accommodate the person so that they can have an equal housing opportunity, then yes, the landlord gets to choose the accommodation as long as it's effective.
So 4 months or 6 months to pay off this pet fee is a reasonable accommodation for charging a pet fee, because it will serve the purpose of ameliorating the immediate impediment to getting the emotional support animal into the house with that person if they truly need that.
Yeah, it could be. It could be, right? Again, that presupposes, and it's a pretty big presupposition, that this person has already demonstrated that there's actually a nexus between their disability and their need for the fee waiver, as opposed to their need for the emotional support animal. The other thing that's important about this opinion is, Judge Vance talks about generally applicable fees and makes the point that, just because a fee is generally applicable does not mean it can't be discriminatory. It can be. But normally when you're looking at generally applicable fees and evaluating whether they're discriminatory, what you're looking for is a disparate impact, whether in enforcing that policy or applying that generally applicable fee, is it having some disparate impact on people who are disabled? If it is truly having the same impact for all people, there are a number of cases, and the judge cites them in the opinion, and I commend that to your listeners, that make it clear that you're not required to give disabled people a benefit. You're not required to treat them better than everyone else. You're just required to treat them equally. And so if you have a policy that treats them equally, that doesn't have a disparate impact on them, generally that policy is going to be lawful.
Yeah, that's very interesting. You don't need to give them a benefit. They just need to be treated equally.
Yeah.
We have historically, as I mentioned before, because we are so scared of this thing, we've outsourced the screening of of all pets, but predominantly emotional support animals, and the associated paperwork to a company called PetScreening.com. And I don't know if you've heard of that company, but they take all the back end work away so that all applicants with pets, or all applicants need to declare either I don't have a pet, I do have a pet and it's not an emotional support animal, or I have a pet and it's an emotional support animal, and then they upload their documents, and PetScreening.com takes care of the evaluation of those documents. But is it your feeling that this case should be in front of them so they can alter or embellish their screening process to include the financial hardship evidence, and determine based on that why a tenant may be rightly or not rightly eligible to pay the fees? Can we just push that onto them at this point, do you think?
I'm not familiar with the organization. I would think that as an organization, they would want to, read this opinion and consider it and decide whether it should impact anything. I guess I would answer it this way. What this decision says is you can ask the tenant to prove that they need what they're requesting. And that what that looks like might be different for different people. And I think in some cases, if you're a housing provider and you have income requirements, if you have income requirements that are multiples of earnings, and you've got a situation like you had in my case, where we're talking about a one-time fee, we're not talking about pet rent. We know, as Judge Vance pointed out in her opinion in our case, it was a one-time fee. She looked at the total cost of the housing over the course of the year, said, it's a very small percentage. So how much information are you going to need in that case about somebody's finances to determine that they can afford it? Probably none. Or not much, not more than you would normally ask for in your application process. And so, I'm not certain that this company is going to need to suddenly be asking people invasive questions about their finances. But I think, on the other hand, I think it may be that they can use the information. Maybe, I don't know what you all supply to them for their consideration, but, I suspect that in many cases, you would be able to make this determination that based on the information you have available initially, it doesn't look like there is a need for the waiver. And then maybe put that back on the tenant to say, if you disagree, prove it. And then they can decide whether they want to come forward and, try to demonstrate financial hardship. But I guess I wouldn't encourage somebody to go, it's burdensome, it's invasive, it's probably unnecessary in many instances.
Yeah. So pet rent was not part of this case, was not part of Henderson v.
Correct.
Yeah. So do you think that I guess that the implication of it not being there and how we kind of square that is the overall pet rent, if it's $25 a month, is that significant vis-a-vis the total cost of the annual rental? I guess would just be the simplest way to put it. Is that right?
Yeah, but again, keep in mind there's two requirements the plaintiffs have to prove here. Initially, they have to prove they need this, that it is indispensable and essential, not that they have the animal, but that they get the fee waived. And only once they prove they need it, then do you move on to whether they can prove that what they're asking for is reasonable. And it's there that you get into those other factors, which is, does the policy have a disparate impact? And, what is how important it is to the housing provider? How important is it to the tenant? How reasonable is the fee in general? But you don't even get to those questions until they make the showing that or I don't think you should get to those questions until they make the showing that they need it in the first instance.
Yeah. My understanding is that Adams and Reese has gotten a lot of publicity on this ruling, that it's been published a number of times, and big media outlets across the country have picked up this ruling and they're kind of publishing it to their audiences. Considering that this story is getting traction and that this ruling is so important for albeit a specific, very specific niche category of society, do you have any sense that the ruling will deter tenants from litigating the issue of ESA fee waivers, or is that a category of society, perhaps, albeit 50% in some states, that won't take this into account and will just go straight to the Fair Housing Authority in their area, and the Fair Housing Authority will make a decision?
Yeah, gosh, I wish I knew. Your guess is sort of as good as mine on that. I will say there's so many people now who, I've talked to people and they just think the HUD notice is the law. Many tenants, I'm sure you all deal with this all the time. They provide the emotional support animal letter. You ask for more information, and then they say, you can't ask me that. That's illegal. You can't charge me that. That's illegal. Part of the reason I accepted and appreciate the invitation to be here today is that, I think there is a general operating assumption out there in the world that is inconsistent with what is really the law. And so, how you change that, I think it's difficult getting people to understand that somebody has now questioned the foundation of this belief. And albeit it's just one court, right? I mean, I think we need more opinions like this opinion, and then eventually maybe people will be able to question it. In terms of what tenants will do, I suspect that they are going to continue to believe, because everybody, it's in the air and everybody believes it is just, thou shalt not charge a fee. It is illegal always if I get this letter to charge me a fee. And I don't think the people on the internet are probably going to change their behavior. They're still going to sell these letters. And so I think the tenant's behavior is not going to change. What I do think this opinion does is it gives something to a housing provider to, when a tenant says, you can't charge me that fee, to say, actually I can, or I might be able to, we need more information. Here's this opinion.
And then cite a bunch of legal doctrine that that they'll never understand.
Yeah, right.
But simply citing it is probably a good tactic for having them back down a little bit.
Yeah, I mean, the real question is, are they still going to go to the, fair housing action centers? And if they do, and I'm sure they will, how are they going to respond to this? And there's any number of responses. How is HUD going to respond to this? Are they going to undertake some other process to try to double down on this position and find some way to support it, substantiate it, put some thorough reasoning behind it so that a different court will reach a different conclusion, and say, oh, I think it is persuasive,
It leads me to one other question. Was Henderson's counsel Fair Housing's counsel? Are they private counsel, or is that somehow affiliated with the Department of Justice?
She was represented by the Louisiana Fair Housing Action Center.
Okay.
So she was not represented by the Department of Justice, but she also wasn't represented by just a private attorney.
Yeah. Interesting.
Yeah.
Your answer to, the statement you made about we hope that other opinions will come out at some point in the future leads me perfectly to the national footprint where Adams and Reese can defend property managers in litigation in defense of cases that may arise from any of our changes to policies towards ESA reasonable accommodations and the fees associated with them as property managers. Can you tell us a little bit about Adams and Reese and where perhaps if we wanted to, we could pursue a defense of a case like this?
Yeah, sure. So I appreciate the question. It's very nice of you to ask. Our firm is located primarily in the South Central United States. So Texas, Louisiana, Mississippi, Alabama, Florida, Georgia, South Carolina, DC, and Tennessee. I think I've covered it all. So, the SEC, basically.
Yeah. Good choice.
What's that?
Good choice.
Yeah. So, we have people who are admitted in other states, but those are the states, and Denver, actually, we also have an office there, but we are, that's where we have, our litigators and lawyers who are practicing in offices. So, we welcome the opportunity. I'll mention this too, that as I said in the beginning, there aren't that many cases that have confronted this issue. And those that have, a number of them have sort of decided the cases for different reasons. But there are the cases that have reached this issue or made a decision that is close to deciding it have generally come out with a landlord favoring opinions. There's a case from the Ninth Circuit of all places that we cited that we thought favorable. There's a case from Georgia that also was favorable on this issue. So I have some level of confidence, especially if HUD doesn't do anything to modify its notice or try to beef it up so someone else would reach different conclusion, that if companies will expend the money to litigate these issues, I think there are courts that will come to similar conclusions.
And I guess ultimately it comes down to how landlord or tenant friendly a state is, and that judge is. And so, what if there's one ruling that's oppositional in its ultimate opinion to the Eastern Louisiana District Court? Eventually that will have to, that's how you say it gets up to a higher level because there's differing opinions. Is that
yeah.
Right?
So I would love to say that you're wrong, that it shouldn't matter where you are and what the court's personal points of view are, but I think that would be naive. So I think I agree with you that the jurisdiction and the judge can have an impact on the outcome here. But yes, that is the way these things sort of percolate up to appellate courts. And, I don't know that this issue would ever, be an issue to go to the Supreme Court, but that is the way that these things sort of progress. But mostly you just need to make more law and have courts pass on this. And that's the point of Loper Bright, is agencies aren't lawmaking bodies. Yeah. And what's happening is you have agencies who are saying what they would like to be the law, or in the notice, in this case, what they call a best practice, what the people in those agencies think is a best practice, but it's been effectively applied
As well.
like it is the law.
Yeah.
And I think we need the courts to pass on this issue and say, and give people guidance.
One thing that struck me as I was reading about this case and about Five Properties LLC, is that they took on a significant financial burden in a way that helps all of us, or with an outcome that helps everybody in the property management space. So it strikes me as a free rider problem whereby we all get to ride on the coattails of Five Properties LLC because they took this financial burden on. So as we go forward and try to create or try to get other opinions, judicial opinions on similar cases, are we best off banding together as property management companies? Are we best off waiting for, if we're a small business like ours, are we best off waiting for a Greystar or a huge multinational property management company to fight this battle for us? I mean, what would you recommend for those of us who are small and don't have the resources?
I would say if history is a predictor of the future, you might wait a long time if you're going to wait for a Greystar or a huge property management company to take on this issue. I mean, I don't represent any of those companies. I don't know what their decision making has been, but it would seem, based on the small number of cases that have addressed these issues, that many of them have made a business decision that it's financially, not worth the trouble to try to do what Five Properties did in this case. And I suspect that they have modified their policies and they have just decided they are going to accept this HUD guidance as though it is the law, even though I think everyone knows there is huge opportunity for abuse here. Mm-hmm. and housing providers are dealing with fraudulent applications. And when I say that, it's really a shame because the Fair Housing Act serves a really good purpose. It is really important. There are people who are disabled who need accommodations. And so I don't want anybody to suggest that that I have an opinion otherwise. But anyway, I think you might wait a long time to see other people do that for you. I think maybe, associations could come together to assist in this litigation if maybe that would be a more effective way.
This should definitely be something that, like, our association, or the National Association of Residential Property Managers, should be looking to defend across the country for all of its members. That's a great idea. Liz, I'm so grateful for you coming on to educate us on this case, Henderson v. Five Properties LLC. In conclusion, is there anything that I didn't ask that I should have asked? Any other thoughts that you'd like to share? Anything else?
No, I don't think so. Like I said, I really appreciate the invitation. I've never been on a podcast before, so this is a new opportunity for me. And anyway, so thank you very much.
Liz Roussel is a litigator at Adams Reese in New Orleans, where she's worked her entire 23-year career, generally representing companies and management to defend their business decisions. In addition to engaging in the full-time practice of law, she manages the firm's litigation practice group across all of its 20 office locations. Liz, thank you again. Really appreciate it.
Thank you. Thank you so much, Matt.
Thanks for listening to the Same Day Podcast. Tune in to a new show each week and be sure to subscribe to get future episodes.